No. And it won't work because I have it going now.
Okay.
Got to turn on the one mic. No, the other one. There you go.
Good.
Yep,
Just spread these
we're
out,
good.
or just leave them where they're at.
Thank you. A little bit.
Oh, these mics are good.
We on?
Yep, we're on.
Hey, everybody. Welcome. Coffee and Bullshit
105.
105. We have our two special guests today, Todd and Eric. We'll let them introduce themselves. I think this is going to be a good one. A lot of great information. I think you're going to find out these are some of the guys who are actually leading the fight to hold on to our gun rights here in Illinois. But why don't you guys go ahead and introduce yourself, tell them about you, and we'll kick things off.
So Todd Vandermeid, I'm a former NRA contract lobbyist for Illinois. I did that for over 25 years. Then worked for parts of the gun dealers in the industry. Did a few other things in my lobbying career. I worked with the operating engineers. I am a retired Local 150 operator. Over 30 years in the local. I'm on the board of directors for the Aurora Sportsman's Club and run a little YouTube channel called Freedom Steel.
Eric Kellis. I am the president of Aurora Sportsman's Club, firearms instructor, all-around 2A guy. My background, actually, I started out as a history teacher, and I do IT now kind of as my full-time gig, but this is where the passions are, and sometimes you just got to go where you're needed. So this is what we're working on right now.
Awesome. And just so you guys know, we talked about taking the $5 from every bag of Cold Dead Hands and donating it. These are the guys who are taking the donation. What's the name of the organization to fund your?
So the funding that agent that we ask you guys to go through is the Second Amendment Defense and Education Coalition, sadec.org. And there's a donate button right there on the front page. And all of that will go to fund pro 2A lawsuits in Illinois.
Yeah. So far, you guys have done an awesome job. You guys picked up 74 bags of Cold Dead Hands since last month, beginning of last month.
Yep.
Yeah.
So awesome.
And I just had one, and it's delicious. So if you haven't tried it, make sure you get some.
You guys are killing it. Appreciate all the support. Keep it going. Certainly, we're just starting the fight now, I think.
Yeah.
Yes.
The bills are rolling in.
Yeah. just got a bill in the mail yesterday.
Yeah. So we were just talking about something interesting before the podcast, kind of the different approaches, where we're at. So you guys are approaching this more from a federal level, from a state level. What angle? I don't want to give away all your secrets so much as you're willing to tell about kind of how you guys are approaching it versus what else is going on out there. And then I think, just like I thought, that all the lawsuits have been kind of mashed together in one, but that's consolidated, but that's not the case, right?
Yeah, go ahead, Todd.
So what you have is you have two tracks. You have the state track, and then you have the federal track. And so you have the Macon County suit with Representative Calkins. Then you have three, or there may be even an addendum for a fourth lawsuit with Tom DeVore down in Effingham County and around there.
Mm-hmm.
So you've got, those are the two tracks for state suits. There was a state suit in McHenry County. It was removed to federal court. There was a state suit in Southern Illinois. It was removed to federal court, all on the semi-auto ban issue.
So what happens to that case? Does that make it a stronger case? Is it a weaker case that it moves to federal court? What's the
Different
reason for that?
rules. There's different rules. So the state court cases between Macon County and Effingham County are not focusing on 2A issues. They're focusing on equal protection. They're focusing on the way the bills were passed through the legislative process, procedural issues.
Okay.
All the cases that are in federal court are working around Second Amendment issues. They are purely federal claims, mostly under the Second Amendment. There are some other stuff about 14th and Fifth Amendment claims in a couple of the suits, not ours. But the lion's share is that they're all the federal cases are circulating around the Second Amendment as enumerated in the Heller, the McDonald, and the New York decisions.
Okay.
Right. So there's a lot of ways you can go about beating this. In a lot of these cases, there's different people trying different approaches, right? It's not that they're wrong. It's just that they are looking at it differently. And one of the things that we see, and we just dealt with this again yesterday, is people wonder why it is taking so long, right? They passed this thing literally almost overnight, right?
72 hours.
And now we're, 3 months into this thing and we still haven't had a court date yet, right? So there's people who aren't, and most people aren't in this system all the time.
Right.
They don't really realize how long it takes just to kind of pull all the levers and pulleys and get the things moving.
Yeah.
Right. So there are faster approaches, and you see that in the state case, in the Calkins case, right, they actually got a ruling already.
Mhm.
They had multiple court dates and they got a ruling. It's now going to the state Supreme Court, but that's moving faster, which I think is why one of the reasons why that people would choose to go down that road.
Yeah, and I also think part of it is I think the other side is gaming things as much as they can. So if you look at the Attorney General's office, the Attorney General's office is typically and notoriously asked for extension upon extension in any
Right.
gun case.
Can we run you out of money and get you
Well,
out before-
there was one where I saw 5 extensions, and the judge finally said, "This is it.
Right.
No more." So you had that. Now, if you look at the McHenry County case that was filed by the state's attorney in McHenry County, they want to go to summary judgment on the pleadings alone. The state is not, because they're not building a record. The difference in what we are involved in down south is that we are building a record. The state. So after we had a hearing on the status call of everything, where the judge took 4 lawsuits that were down in the Southern District and combined them together, consolidated them, and said, "You're the lead case now. Okay, so everything will fall under this case, and you guys are all in line. What happens in one happens in all 4, right?"
Okay.
So what happens is that down there, Kwame got put on a schedule, and now they don't have the opportunity to drag their feet. But you look at the Veramontes case, which is in the Northern District in Chicago, challenging Cook County semi-auto ban. That thing's been out there for almost 2 years.
Right.
And Cook County was dragging their feet. Now, all of a sudden, Cook County wants to put the gas to the pedal, or pedal to, they just want to fly, because now what they want is, and they are flooding the court with declarations to build a record. They're not building a record necessarily for this. They're building a record for the Court of Appeals and so on. And so everybody now wants to get ahead of what we're involved in down south, because they want these bad rulings. So it would be our side taking the appeal up. Naperville, we got a bad ruling. There's very little record. It's all virtually on the pleadings. You can go through the judge and what the judge said, where there was no record about this. There was no contradictory information to this or whatever. So, everybody, there's always this race to be first, and being first isn't always being best.
Right.
And so, yeah, we took a little longer in getting the complaint drafted that we're involved in, because we wanted to hit certain points and tune it up. I can tell you that in our case, ASC is not a named plaintiff. We are working alongside the Federal Firearms of Illinois, the FFL-IL organization. They are the named plaintiff in this. We're working alongside them, and we have a say in what's argued in the courtroom. We have a say in the arguments being put forward, in the way they're presented in the briefs, and I don't think, if you talk to any other group, that they are this involved, this ingrained in the litigation. And that's, that way we have a board to answer to. I mean, it took all 16 members of the board to sit there and say, yeah, we need to go after this to protect our members. And in doing all that, at least they're probably some of the most informed guys about what's going on outside of a couple of us that are living this day to day.
Right. And if you look at the way most lawsuits are handled, right? So if you're done wrong, you hire a lawyer, right? You pay them, and they kind of do everything,
Mhm.
right? And that's not been our strategy from the very beginning. The thing that we're really trying to do is we live this. We understand these issues. We know what the differences are between a lot of these finer points in the law. Lawyers aren't necessarily gun guys, even if if they've done 2A cases before, right? They're lawyers, and we are feeding them information, going, no, look in this pleading, this makes no sense. These two things are contradictory, right? Their expert witnesses got this all wrong. Those types of things, and that kind of eye into what's going on that a lot of these other cases just don't have.
Yeah, it does. And I think that our reply to the state is due this coming Thursday. And the judge, in his order over a month ago, sat there and told the state, and by the way, I want illustrations of everything that's banned.
Oh, right.
Not every
And so-
gun, every item,
Every item.
So you can find that. And I don't know, maybe
How many pages is that?
well, that the state turned in 76. On that item alone, they turned in 76 pages, photographs and whatever. My job is now to catch all the stuff they missed and they missed a ton. And there's a couple of things I can't talk about right now, but once the documents are filed and they're a public record, then, and I'll tell you what, there are going to be some people who have the I could have had a V8 moment for the stuff that we are going to point out that if you take a couple of paragraphs that they have in the law, black letter, verbatim, it's more expansive than most people realize. It's more expansive. And I think there are some downstate Democrats who thought they had skinned a cat on some stuff. I think they are going to be shocked by and I can justify everything I'm going to purport is out there.
Oh, I mean, even when I read the initial ban, it was like, the scope is super broad. It's very narrow. It doesn't really describe what all these things are. So now they're left a lot of gray area in this whole law, like even stupid things like some of the triggers. I'm like, that's really gray here. And this rifle, whether you're banning this or not, that's really hard to tell. And so I think you're right. I think the implications way beyond what they even thought, what they know.
And that's going to be our job to point out to the judge all the things the state missed and why we think this, and one of the things that the state, so there's an argument the state is making. So if you go back to Heller said, if it's in common use, it's protected. And they said there's an exception for dangerous and unusual firearms. Okay. Well, one, they're trying to claim dangerous or unusual. And the way they're trying to get to dangerous and unusual. So if you listen to this and then you start reading what they're writing, they're going after the ballistics of the 223, 5.56 round. And they have doctor after doctor, whether it's California, Illinois, whatever, filing these declarations about the trauma caused by, the bullets that are coming out of an AR using the 5.56 round as opposed to 9mm. I think they were saying that like a 5.56 is 3 times more devastating than a 9mm or a 45 ACP, based on this measuring system that they have. Okay, fine. They don't do anything take into account pistol caliber carbines.
Mm-hmm.
Number one.
Mm-hmm.
But they are trying to use this whole bootstrapping of the velocity of rifle rounds to get to this is how dangerous these guns are. Point number one. Point number two, when we say 24 million ARs, well, a lot of guys like to argue that. I think we're missing the point when we argue that. That's one gun.
Mm-hmm.
All right. But they want to say, well, 24 million ARs, only 2% of the American population potentially own these. That's a drop in the bucket. That is not in common use. That's how they are trying to get to these arguments. Okay. At the same time, our side, what we argue is that it's not the AR-15. They banned semi-automatic magazine-fed rifles in that category. And when you take that category into account, okay,
Right.
It's not 24 million.
No,
And if you look at and then if you throw in quote their term assault pistols, if you look at the Congressional Research Office on the pistol brace issue, they said there's between 10 and 40 million. Okay. And how many pistol braces went to a firearm that's not a semi-automatic?
Right.
Very, very few.
Right. Most that's what it'd be, right? Who's going to put it on? You're putting on what, a revolver?
Right. Yeah.
Or I don't know what, a sawed-off Henry.
Right.
In
So
this day and age, there's not many single shot pistols.
no. So the point is that if you use their numbers, we need to look at, if you think about some of those popular firearms like the Remington 870, there are 11 870s manufactured. And this ban is not
11 million.
11 million.
Yeah. Yeah.
Shot. That's one version of one
Right,
shotgun.
Yep.
There were like 4 million Browning A5s. Okay. So, and these are the numbers. So you start adding all these up, we are no longer at 20 million. We're easily knocking on 100 million
Right.
firearms that are being, talked about or caught up in this one way or another. And when you look at all that, that's where their unusual part. We just have, some of these things just need to be tackled head on and smacked down. And it's going to take a couple of judges. I think Judge Benitez in California is going to take some of these arguments, and I think he's going to beat them in the forehead like a rented mule with a 2x4. And that's, and all this plays. So if we get a ruling out of California before we go to oral arguments,
This could happen any day.
then we can incorporate that.
Yeah.
If we get a ruling out of Maryland. So Maryland's gun ban was one of the 4 cases remanded by the Supreme Court last summer. Back in November, they had oral arguments on that case. And what's funny is everything they're arguing over there, they're arguing in Illinois. All these anti-gun attorney generals are talking to one another, and they're setting up their arguments. And you can read it, you can listen it. Like I said, so now they've got this other little game. They're trying to say that it's only firearms for self-defense actually used in self-defense, which is not the test at all. But that's what they're trying.
I don't remember any part of that being in the Second Amendment.
No, but under the Heller, it said it is, you go back to Heller. Heller said for lawful purposes such as self-defense within the home. And right after Heller, all we heard about was it's only handguns in the home. That's all we heard for the longest time.
Mhm.
And then we won the Kerry case in Illinois, which said, oh no, you can carry outside the home. Okay.
Yeah.
And so now they're trying to drive a bus through every little thing. And in Maryland, in their oral arguments, they said, well, these guns are not used for self-defense. Now, Cook County has made the argument in federal court that it's illegal to use an AR-15 for self-defense. It is excessive force. You are no longer in a self-defense mode. You're in a retribution mode.
You use way too more force than you needed to in defending yourself.
So what if the guy's breaking my house has an AR?
I'm just telling you.
I can't return equal fire.
Well, I mean, if you saw the video where those 3 guys jumped out of a car almost in front of cops and lit up a house, you know what? I've talked to my state's attorney. My state's attorney has a vastly different view of what Kim Fox and company is saying.
What's the most ridiculous thing? That's overkill. So how do I know as a citizen where you're going to decide the line is what's overkill, what's not?
It doesn't. But that's where Todd mentioned earlier that they're trying to bootstrap these things.
Mhm.
And a lot of people might not be familiar with what that terminology is. What does it mean to try to bootstrap an argument?
They're just trying to pick something up off the floor, and they're just trying to pull it up there and get it up.
Right. There's no precedent. We're trying to create a new argument against the thing that we don't like. Right. Out of whole cloth in many cases.
That's what those 2 loops on the side of your cowboy boots are.
I know what it is. I just want to make sure everybody knows.
Well, they're trying to give them where the reference comes from.
So let me ask. So the thing that concerns me is there's 9 other states that have upheld the assault arms ban.
All right.
So what do we do different to avoid that?
Now you're falling into the JB claptrap of talking points. There have been 8 other states in the District of Columbia. Number 1, when Heller 2, which was their challenge to the semi-auto ban, went up in District of Columbia, a appellate court justice by the name of Kavanaugh wrote a dissent about how the majority was wrong. These are in common use and protected. That is now Supreme Court Justice Kavanaugh.
Right.
Okay. Number 1, all the other challenges that had gone up were prior New York.
Okay.
So New York, when it came down last summer, is an absolute game changer. Did the other state people not in the other states not challenge this? They were, but the problem was we were waiting for the right case, and we would have been here a year sooner, except when New York was on the verge. New York had a transportation law, and that transportation law said if you had a pistol permit, you could only go to 1 of 7 ranges in the city of New York.
Mm-hmm.
If you had a house in upstate New York, you could not take your pistol there without it being illegal.
Yeah.
That case was in front of the court and briefed and argued, and then New York changed the law. They saw they were going to get crucified in this decision, and they changed the law. So the Supreme Court mooted out the decision. Now, what's good? Now we have a 6, potentially conservative justices on there. So now, and when New York, under the New York v. Bruin case came out, now they went back and they told all the lower courts that you're using this 2-part test. Remember when the first semi-auto ban was challenged in Illinois, Friedman and that was done against Highland Park. The judge came out and said if it makes them feel safer, that's a good enough governmental reason. Feelings matter.
Feelings.
That's
matter.
in the decision.
We were all beating our head against the wall that day.
Oh yeah. So
Wow.
so that's they use this old two-part test to just shoehorn everything under intermediate scrutiny. And and if you go back,
And the term that's related, that they call it interest balancing.
that's it. And so that becomes important because if you go back to the original Heller decision, if you look through the Heller decision, go to the bottom of page 63, and it says we know of no other enumerated constitutional right whose core subject is subjected to an interest balancing approach. The very enumeration of that right takes out of the hands of government.
Think about the dangers of doing that. So now First Amendment you can take away because
It's always been
It's always been that
it's
way.
always been an interest balancing with the First Amendment. That's
Yep.
where you get strict scrutiny, intermediate scrutiny, or rational basis. And typically, content-based First Amendment speech falls under strict scrutiny. That's why, okay, child pornography, that's illegal, but consenting adults is not. It's this threshold of the scrutinies. And so they were shoehorning everything in under intermediate scrutiny in those 8 or 9 cases you talked about prior. And that's where JB keeps going, hey, this has been up. No, this is upheld under a completely different standard.
And the thing that and I just want to be clear, right? The thing that they would say is the state has a significant interest in protecting public safety. That is the interest balancing. That is the state's interest.
Yep.
And in the courts would say that outweighs your First, Second Amendment right.
Gotcha.
Right.
Okay.
And
Right?
so
That's where that comes from.
And so that's what JB's talking point has been that, oh, look, it's been upheld before. That was all pre-New York. So back in November, they had a case in front of the Court of Appeals here in Chicago called Atkinson. And it's about a nonviolent felon trying to get his rights restored. And the chief judge sat on his 3-judge panel along, with 2 other judges. And 20 seconds into this government's case, she just started ripping him a new one. And they sat there and said, look, the Supreme Court has reset the table. It's a new day. And they said, if are you going to go back and do the work to show what historical analog existed in 1791 to justify the regulation? Because that's the test. Okay. And what do they, and they literally said, look, if you don't do the work, they win, you lose, is what they told the government. And then when he went on, I did a couple videos about this. The case is called Atkinson. And this other judge sat there and, well, this is for law-abiding citizens. And he's like, hey, counselor, I don't think you can sign us up for that carte blanche. The Supreme Court has issued a new day. And they, at least those judges on that panel, were taking it to heart. And so, and I will point out, Chief Justice Sykes, who was on that panel, was one of the 3-judge panelists in the 2 Ezell cases when the district court ruled the Chicago range bands were okay, that got it wrong. And she said, no, you got it wrong. And oh, by the way, the right to acquire is included in the Second Amendment. So is the right to maintain proficiency, which becomes important because under the New York test, we start with the text. If it's covered by the plain text of the Second Amendment, the conduct is protected. The burden shifts from us to the government to prove that that they have the ability to regulate this based on history and tradition. And that's where, you had a court of appeals in Texas sit there and say these civil DV restraining orders about firearms possession or ownership are unconstitutional. You've had at least one other court say felons, nonviolent felons, it's unconstitutional. You've had a court out of Oklahoma say that the prohibition by marijuana users is unconstitutional. So you've got these things that are slowly building. Now, what's interesting is what the federal government's doing. So they lost a case on bump stocks, not on 2A grounds, on Administrative Procedure grounds. They didn't follow the Administrative Procedures Act, and this is outside the authority Congress gave ATF.
Right.
They lost bump stocks. Everybody thought they were going to appeal.
Right.
They didn't appeal. So right now in Mississippi, Louisiana, and Texas, you can buy and own bump stocks is not a violation of the NFA. Now, down in that same district, you also have pistol brace rule, and you've got the 80%er rule pending in the courts. You've already had on the 80%er stuff, one judge issue an injunction against ATF, enforcing it against certain companies and their clients, their customers. So it again is another Administrative Procedures Act. The pistol brace rule will be the same way. So I think they're going to have to appeal something unless they are adopting a strategy that, well, we've only lost Texas, Louisiana, and Mississippi. If you'll remember, when we go back to when Illinois got concealed carry, Attorney General Madigan did not appeal up the loss at the appellate court. When the appellate court found in our favor, overturned the district court, gave it to us. Okay. So, and that was because what we're told is Bloomberg's people said, look, if you go up, now this is 2013, this is only 5 years post Heller, 3 years post McDonald and the Chicago ban, that if you go up and you lose, because it's a complete ban on carry, you've lost the country. So it took until 2022, 9 years later, to get a carry case in front of the court. One of the things that we had heard through the legal pipelines was that a certain justice was not going to let a case go on the gun side if he didn't think he had the 5 votes to win it. And so it was making sure that, we got the right win. And with all that. So this is all the in the weeds kind of stuff that a lot of guys don't hear about. Right. But the fact is, the first gun case that is done under New York at the trial court level will be the California Miller one with Judge Benitez and his Duncan case on magazines. The first Court of Appeals test will be out of Maryland in the Fourth Circuit, which has already been argued on orals. So that could go up. The question there is, if Maryland loses and the Fourth Circuit says, nope, Maryland's gun ban is no mas. Okay. Does the Attorney General of Maryland want to appeal it up? Because if the Supreme Court takes it and rules in our favor, then the whole country's gone.
Yeah.
So this is where, what kind of strategy are they going to play? Because that's what they're trying to play with our cases and trying to get the cases that don't have as much effort into them being run up faster and leaving our case try to slow walk us a little bit.
Well, and the other piece of that I think is not really visible by the public is that we are not even arguing. We've got a court date next month. It's not about necessarily reaching a final outcome. We're just trying to get in a temporary injunction,
preliminary
injunction, right? So whichever side prevails in that hearing, the other side is going to appeal it. Right. We know, everybody knows that. When Todd was talking earlier about establishing a record, we're trying to establish that record. So when we get to the next level, whether it's us initiating the appeal or the state, we've got all that groundwork already laid, and hopefully at least goes a little bit faster, right? And you establish the fact pattern before you get there.
Right, because we could be, with our fact pattern, even though we're only on a preliminary injunction, we could have a better fact pattern than cases that are farther along in the process. And it would be much nicer to have the Attorney General have to appeal a loss than our side appealing a loss like you're doing in Naperville, like you're potentially going to do in the Cook County case or anything like that. And so we have a different theory and a different strategy, as well as our lawsuit that we're involved in is the only one that took on guns and parts. Everybody else wanted to take on guns and mags. And we had the long conversation and came to the conclusion that there was so much stuff that we had seen the other side start arguing about. Magazines aren't arms. They aren't protected. They aren't that could just take up, pages and pages of argument. So why don't we stick with guns and parts and our stuff? We got consolidated with these other cases. Paul Clement and Aaron Murphy are the lead attorneys in the Barnett case. And then the other cases fall in behind them. Our attorneys have a good working relationship with that law firm. So, and just Paul Clement was the guy that argued New York and won New York at the Supreme Court. State of New York is now complaining about the $1.4 million bill they are facing for our side to recover attorney's fees. They want to whittle it down to $330,000. And it looks like I saw that they were complaining that an attorney was billing at $1,800 an hour. I think that is Mr. Clement from what I hear about his billing. But when we ran, Paul Clement got half the time to argue McDonald for the Chicago case. That was an NRA function that I was involved in. And so when back then he was billing like $800 an hour, and the city of Chicago wrote the National Rifle Association checks totaling $1.2 million for our end of that. And we got every billable hour Paul Clement put down.
Nice.
So we'll see. I mean, our goal is to make this monetarily painful
Right.
for them.
That stops further appeals, right? And it stops challenges again in the future too.
We'll see. We don't think it's going to take the Supreme Court and some real heavy-handed sanctions to stop these guys.
It's not their money,
Right.
right? They have no personal
Right.
skin in this game,
Oh,
right? It's virtue signal.
that's crazy. So, how long do you think it's going to take to actually have a real resolution? Another year? Another 2 years?
It's hard to say,
Well,
right? We're hoping to get.
I mean, as long as Pritzker's in office, right? That's going to be. It's never
well,
gonna
no.
happen.
In April, I think by the 1st of May, we should see something out of our judge. If we prevail on a preliminary injunction, then that goes into effect.
How long will that be good for?
Unless he stays it or until another court stays it, it'll be good. In
Through the
California,
duration of the completion of our case.
So if the case takes 5 years, it'll be good for 5 years.
if it's not stayed by the higher court,
Right.
yeah.
Wow.
And so, we go back to January 9th. You had in California when they had the first magazine ban overturned,
Mhm.
they had Freedom Week and millions of magazines flowed into. I mean,
Yeah, everybody stopped shipping to other states. Like, let's flood California
Yeah,
while we can.
let's get those guys taken care of. So it depends. If we are granted an injunction and it's not stayed, then it's for the duration of the court case. But let's not forget, you have Maryland, which is at the Court of Appeals. That could be the first case to get to the Supreme Court. If it hits the Supreme Court, so you're going to see a decision out of that any day now,
Mhm.
which means it would be on the docket for the 23-24 court calendar for those guys, which means if you run it out till June of 24, you could see a resolution on the semi-auto ban from the Supreme Court as early as June of 24.
So the president this week signed what was that?
An executive
order, right?
Yep.
Yeah.
To ban semi-automatic weapons. What does that do to the state, other states? Or
Well, it doesn't really ban semi-autos. What he went after was background checks and a bunch of other stuff. And really, it's all window dressing and fluff because he can't mandate background checks on private sales by virtue of an executive order. That's a function of Congress and what the law says, who has to do something. Okay. So you've got that. Well, what he's trying to do is change the definition of who is engaged in the business to try to get people who privately sell a certain number of firearms to be considered engaged in the business.
Okay.
All right. There's lots of nuances in this. The problem is most of it was window dressing and virtue signaling, like Eric said.
Yeah.
Right. And here's what they know. If you watch the integrity, are they winning some cases here and there? They are. They get in front of favorable judges who either on purpose or through ignorance keep applying the old standard. There's not a case that at least that I've seen where they take the Bruin standard, apply it, and we lose. Right.
Naperville's the
Naperville.
only one, and that judge was just
But she didn't apply the standard.
not appropriately.
Right.
She
comes out at the beginning of her decision and says, "Oh, there's a new standard," and then proceeds to ignore it.
She did not apply it in a proper venue. My Cook County ammo tax case, the judge just said, "Yeah, New York doesn't apply." It was a 1.5-page order. I mean, so they didn't even apply it there. They just said, no, it doesn't, which we're going to have that case up on appeal here before too long. We've filed our motion for an appeal, and now we just got to have to finish writing the appeal.
So the other thing I want to go back to real quick, Todd,
Yeah.
is how many of these cases are really brought to conclusion in the preliminary injunction phase versus going through a full set of arguments and an actually ultimate decision based on the merits of the case?
Most of them, because
Right? And that's a piece that people need to understand.
Heller was not resolved on a fact finding in the trial court. Heller went up on what's called an interlocutory appeal over the failure to get a motion for a preliminary injunction. All right. And so McDonald did not go up on a loss at the trial court. McDonald went up on saying, hey, based on Heller, we should have an injunction against this
Until the case finishes.
One of the few cases that was up there was Duncan, the magazine ban, and Miller, the semi-auto ban out of California, actually had final rulings from Judge. I'm not sure. They went through a lot more. Judge Benitez issued 92-page rulings on these things. So, but the vast majority of these cases are end up going up without a full record on a challenge over an appeal.
So I saw on Thursday, Senate Republicans just introduced a new bill to codify owning guns outside your home. They said, right? They're saying that there's nothing in the Second Amendment that says you can't own a gun outside your home or use it for self-defense outside your home. So do you think that will be of help in this case?
I don't know. I haven't read it. It would depend on how it's, it would depend on how it's written. That's everything. And I haven't.
That just popped up Thursday. I saw a little bit. So I was trying to read more about it. Now we're talking, but Graham introduced the bill and they had Senate Republicans back at their challenges. They're trying to codify Heller and Bruen and say there's nothing in the Second Amendment that says you can only own this gun inside your home and that you can only self-defense inside your home.
Well, yeah. I mean, I think it's as much virtue signaling as anything because with the Democrats running the Senate, it's not going anywhere.
Right.
Biden is not going to sign that if it gets there.
He said no matter what he's going to ban assault weapons, no matter what.
Well, he doesn't have that power unless he tries to do.
He thinks he does though. He pushes through, executive orders all the time. He doesn't really care.
He likes ice cream too. I mean, he can't walk up the stairs to Air Force One.
Doesn't even speak English. So it's crazy. I hope we figure out some kind of real resolution to this and don't have to keep fighting for our Second Amendment because my fear is as soon as you let that one go, then the other ones just start to fall.
No, I think we're going to come to a but they are going to continue to find nuanced ways to try. I mentioned earlier, so dangerous and unusual. They've actually made the argument in court pleadings from anti-gun lawyers that Blackstone's dictionary says dangerous or unusual. And they're saying the court got it wrong. Well, wait a minute. So we had Heller, 5-4, right? So that's 5. We had McDonald, that was 5-4. There's another 5 votes, right? Catano for stun guns, which dealt with the Second Amendment, was unanimous decision. There's 9. And then you had New York Bruen, which was another 6. So you've got 25 votes by Supreme Court justices. You mean to tell me that 25 justices and all of their clerks over 15 years got it wrong? Because that's really what you're saying. They got it wrong. They couldn't figure. There's a typo that they have consistently ignored. And I don't buy that. But that is every little nook and cranny. They're trying to drive something through.
And our job is to put them in a smaller and smaller box, right? Is it ever going to totally stop? No, right? But we have to all they're going to be left with is crumbs eventually if the strategy is successful.
How about the Illinois FOID card? Is that? I mean, it just seems like there's always something going on.
We were just having a conversation about that the other day. There is all right. So there is a challenge to the FOID card taking place in state court in Sangamon County. That will probably go up on an argument schedule later in April, would be my guess. And if they prevail at the circuit court, then that will go up to the state Supreme Court on par. It'll be a direct appeal by the Attorney General's office. You just had this last week, the appellate court for Maryland. Maryland passed something like a FOID card in 2013, and they just had oral arguments at the Court of Appeals last week. It did not go well for the state of Maryland. Maryland twice, the Attorney General of Maryland's office twice admitted that when the judge says, I'm waiting for the historical analog to this type of, and they said, we couldn't find any. And the judge, and the second go around, well, you've already admitted we don't have any. So in his thinking, the test is possession and ownership of handguns under their FOID card. And, so it covers the conduct, and you have no historical analog directly on point about pre-permits to purchase.
A FOID card does nothing but slow you down when you're buying ammo. All
And
it really is an ammunition restriction card.
Well, it's guns and ammo, but the other part of it, there was,
But I can't buy a gun without a background check.
right.
All the FOID card says is this guy at one time had a background check. That's all the FOID card says, right? And then when I go to the store to buy ammo, I show them that proves that at one time they did a background check on me. That's all it says.
No, you actually, if you are a FOID card holder, they cross-reference you every night, except for Christmas and New Year's, against the known criminal database.
They do it every night.
It's every day.
So,
for 2 days.
so how does someone?
There's two checks. There's a check against the criminal records index for new records, which more guys are getting scooped up because of digitizing of
Yeah.
records from
Right.
smaller counties,
Right.
from
Well, it's better
things,
now before than
whatever.
they used to, right?
and so you have that. So you have the old stuff coming into the system plus new arrests, and that's another standard that I think is unconstitutional. But then you go on that they also bounced it over to DHS, Department of Human Services, for new admissions to mental health stuff.
Right.
So you get like 360 checks a year outside of any time you're called in for a new gun purchase. The FOID card is redundant. It's useless. The only thing is that, at first blush, a cop, sees a FOID card, presumptively, you're not a shithead. So there's that. But in Maryland, our side, we're not involved in that case, but the pro-gun side did a very good job of sitting there and saying, well, Your Honor, it's not just 30 days. You have to get fingerprints. That costs this much and takes this long. And, oh, by the way, you have to take a training class in order to own a handgun in Maryland, not just carry one, own one. And so that costs about this much, and it's a minimum of 16 hours, and it's this and it's that. And he said, so typically it starts at 37 days. And the judge kind of got into it a little bit, asking, well, and then he goes, but there's still a check when you go to the gun store. Yes, Your Honor, there is. So this guy was getting into it. He was, and I think the problem is, good for us, bad for Maryland. The 3-judge panel, none of the judges were from Maryland. They have this Eastern Seaboard. There's them, South Carolina, Virginia. They're all in this district, right? And they just are not drawing judges. They're drawing judges from South Carolina and Virginia who are more gun lovers.
Right.
And so they're like, you got to do what to buy a handgun? And they're trying to get their heads wrapped, like us in Illinois. We grew up with this. We understand the system. People go, you have to do what?
Uh-huh.
And so these judges getting educated about that. And, Eric's listened to some of the orals. And I think that there are a number of judges who are truthfully, honestly, have looked at the New York decision, are trying to fairly apply it.
Yeah, I think that's true. We were talking on the way up here just about kind of what that looks like big picture, and what percent of the judges are really educated to where they should be on this stuff. But it's really interesting. But the other thing that kind of goes right along with that, right, is the Second Amendment is what we call an enumerated right. It's listed in the Constitution. It's not one of those implied rights, right? Well, what else have we got in there? Freedom of speech, freedom of religion, right? All those things. Imagine if you had to go get government permission to do this podcast, right? It's another enumerated right, right? To treat them differently, right, is facially ridiculous.
Well, there's no other right that you can take away without a legal trial. Whereas you can red flag me, take away my gun rights without any kind of legal trial. I have to prove I'm innocent
Yeah, we're
Rather than
gonna
proving-
win on that too.
rather than proving I'm not guilty.
I think that decision out of Texas has got the anti-gunners
Worked out.
shitting in their pants.
Yep.
I think they are very, very nervous about what that means because the judge that wrote a concurring opinion went very much down the road that if they are this dangerous, they need to be pretrial detention. There are steps we can take. And in the criminal justice system, you get more due process than an ex parte civil process. And that's where he was making a distinction in that. And that's where I think that I even saw a couple of comments out of some of the anti-gunners that I think the hierarchy, the legal beagles understand that all their ex parte, we're going to run to court and and now they keep trying to expand the layman that can file this. I think they have a very tough road to hoe going forward. The question is who's going to be the first guy to bring that case.
Mhm.
Remember in Illinois, so you now have two challenges to the suppressor ban. You've got a challenge to the ban on guns and home daycare. You have a challenge to the ban on carry on mass transit. All right. You've got these other ancillary, you've got a challenge to Chicago's ban on laser sights. All this, those are four that are outside of just the semi-auto mag ban kind of stuff that we're talking about. And it's only going to get worse. My goal is by the time we're done, the Illinois gun laws look like Freddy Krueger took his claws to it.
What do you think of the combo concealed and CCW card?
I hated it. I
Yeah.
was against it. It didn't pass until I was gone. The reason we never went for it in the beginning in 13 was you can lose your right to carry for things you can't lose your right to own a firearm for. And having a single card, in my mind, made it harder for that if they were going to jerk you around on the carry stuff. And that goes back to where we have the state police are sitting there and they say, well, if you've been arrested, we jerk your FOID card. Okay. And if you're if you get probation for a DUI, well, your FOID card's jerked anyways. Okay. But wait a minute. Take a simple battery. You're at the bar, some guy grabs your wife's ass, and you turn around and you haul off and cold cock the guy. Simple battery. Nothing there means you lose your right to own a gun.
Right.
But because you got arrested and a condition of bail might be no firearms, you lose your FOID card, lose your carry license. Let's say that you even take a plea, supervision, whatever. Well, wait a minute. Even though the conviction is not a prohibited factor, you lose, so that's a challenge that we are looking at, from the legal side of everything. Like you said, you can lose your right for X. You don't lose your right to free speech. The only time you lose some of your rights to free speech is when you're incarcerated.
Mm-hmm.
So absent that, you lose your right to vote while you're incarcerated, except
They're
now
trying to roll that back.
they're trying to roll that back. So, there are all these nuances of everything to go after. And the laundry list is yay long. It just is and I think you'll see some of these other issues get tackled in other states and it'll all kind of funnel in. So Maryland, okay.
Right.
If Maryland prevails on their appeal on their FOID card, then obviously that's going to have an impact on what we can do over here that we can point out. And the one thing, Eric was a history teacher. They ain't making any more history from 1791.
Actually, historically, that has been a thing where people try to create history. In the age of the computer, that's a whole lot harder to do.
Right. So if the test is analogs and laws from 1791 or maybe 1865-ish, okay, they ain't making any more. So you just had the state of California drop 300 laws on a judge. We think these apply. And then the judge says, no, you have to tell me exactly which ones apply. You now had the state of Illinois hiring experts. You've had Cook County hire 11 experts. You've had the state of Maryland go through their stuff. You have California or New York go through their stuff and their carry challenges, which are up in front of their Court of Appeals Monday, their answer to the New York decision. And you just had oral arguments in a case on carry in New Jersey yesterday, where, with all these states spending all this money, whether it be internally within their own legal departments or externally on experts, at a certain point in time in the very near future,
You've discovered everything there is to discover.
we've got it all. And there's not going to be a lot less to argue under this test. They've gone so far in the gun bans and mag bans that they're trying to bootstrap in stuff about Bowie knives.
This is running out of shit to do. It sounds like.
Well, again, it's about the size of the box. I keep going back to this. They cannot win under the standard as we've been discussing it here today.
Mhm.
So they have to change the argument somehow, right?
Makes sense, right? After losing the game, change the rules, right?
Right. So that's got to be their strategy because that's all they have left.
What they say in trial court? If you have the facts, you argue the facts. If you don't have the facts, argue the emotion. And if you don't have any of that, you argue the person. Okay, you do all that. So here, the racetrack they have to run on, in my mind, is going to get progressively smaller. And I think, if you go back to the New York case, they took 3 analogs from the 1900s and said, nope, those don't apply. Okay. And in cases you keep trying to see these guys bring in analogs from the National Firearms Act, which is well beyond the time that anybody said was, that what the court has said is allowable. So we've got these 2 periods, and one constitutional lawyer sits there and says he goes up to about 1825-ish, because that's when the last of the founding fathers died. And you would have had the last of the knowledge and intent of what went on there, right there. And he goes, that's, and then you get the second window. So I think that we're at that part where we see the light at the end of the tunnel, and I don't think it's a freight train. I think we're on a shorter path than what we were in 2008. Nobody thought it was going to take this long. And I have these anti-gun liberals that I end up in arguments with online from time to time. And they say, well, you keep saying Heller and New York. He says, well, Roe was settled law. Well, no, Roe was not settled law. And you know what? You had 50 years. I'll take 50 years, okay, under New York. And let's see where we are. I won't be here, but let's see what that looks like. Because in the short term, I think it's all good for us. And I mean, you give me the biggest thing that our guys need to think about is Mitch McConnell and Donald Trump did a remarkable job of filling the judicial vacancies. And now Biden and the Democrats have saw what that did, and they're trying to push as much stuff through as they can. We need a Republican Senate, and we need a Republican president to sit there to go back and fill in everything we could, because Trump almost got the Ninth Circuit Court of Appeals to a parity between Republicans and Democrats. We're within, I think, 2 seats now. Okay. Not that look, Dwight Eisenhower, a Republican president, when asked, do you have any regrets? He goes, yeah, the 3 of them are sitting on the Supreme Court. So, it's not always, remember that Sandra Day O'Connor was a Republican appointee and not the best for us.
Yeah.
So it can go, but the types of judges we have been getting as of late, I'm very happy with. But we need to do what they did. Bush did not fumigate federal government when he came in post Clinton, and all the Clintonistas stuck around and they stuck it out until Obama, and then they just burrowed in deeper. So we need to make sure that we get qualified gun guys who are looking out for our interests inside the State Department, because that's import export. Okay. And then we get guys in ATF, Department of Justice, Commerce, EPA because lead in ranges. Hello. Okay. All these things. And then you want the Department of the Interior because they're trying to go after lead ammunition over condors, and stuff like that. And we need to fumigate, the people that don't believe in the Constitution, and and think that their judgment is better than the administration that's there. And then we start setting ourselves up.
And just how the ATF interprets and administers the laws that are legitimate, right? We're hearing reports now, and I haven't heard of any of our guys that have been impacted, right? But if you make one little small paperwork mistake now and you're an FFL dealer, they'll pull your license, right? That's what's kind of reporting that because they can.
Right.
Historically, that's not what they've done. We're going to guide you. This is how you fix it. Apparently, at least some of the reportings indicate they're not interested in doing that anymore. They just want to get rid of gun dealers.
Well, because if they have the Heller and the New York decisions out there, what do they need to do? They need to choke off the supply.
Mhm.
They need to choke off. Well, when they pass the gun dealer licensing in Illinois, ATF publishes a spreadsheet every month of active FFLs, and it, the numbers dropped in half when they passed the GDL. Okay. And now, if you talk about adverse reactions over guys selling guns right now, you're potentially looking at, another 10, 15% of gun dealers in Illinois getting shut down by jerking the state license. I mean, there's a whole host of things we'd like to go after there, but it takes money. We really appreciate you guys and the donation, because our goal with this is to prevail in the gun ban, recoup our attorney's fees that we're gonna have to front load on this.
Yeah.
And then Eric had, when he started talking about this, had a vision. We're going to then use this as a bankroll to start taking down the other things that we want to take down.
Yeah, we've got a list of stuff that we want to go after, and it's entirely driven by our ability to finance lawsuits. And it's not new, right?
This always is, right? Who can afford the lawyers?
Right.
That's not what's right or what's legal. It's who can afford the best lawyer.
Understand taking a case like this to the appellate court level is about $250,000.
Yeah.
And and I got a question. Well, how come we don't see any gun company names out there? And I'll give you the answer. It's very simple, because if you pick the gun company, whether it's Glock, Smith & Wesson, anybody, if they become a named party, then they open themselves up to discovery. And what have, you saw the Remington lawsuit, you've seen some of this others. What do they want to do? They want to dive in and get into all the corporate books and all the nooks and crannies. And so you very rarely will see a company like Smith & Wesson or somebody be a named plaintiff in a lawsuit. Now, they were a named defendant back when Chicago tried suing all the gun companies for their selling practices and stuff, but Chicago lost that at the state Supreme Court.
I just don't get. What's funny to me is it's so strange that most police officers that we talk to, run into, are very supportive of gun rights. It seems the ATF is completely opposite, and they just want to take it all away. So what's the difference? Why are those guys so against when everybody else, every other LE we talk to, is all about supporting it?
So I don't think it's the everyday ATF agent probably doesn't care. They're trying to do their job, right? They're trying to feed their family like everybody else. And especially if they've been around a while, right? This wasn't nearly as bad as it is today, even 10 years ago.
Sure.
Right? It's the people at the top of those organizations, right, who set the policy. Well, you work for the ATF and the bosses say this is what you got to do. You like to feed your kids and have them be able to go to the doctor when they're sick, and that's what you got to do, right?
Yeah.
Some of those people are stepping away. We've got some members at the club who are just cops, right? They were Chicago PD. One guy literally walked off the job at his lunch break. He's like, I can't do this anymore. What am I doing here?
That's what I said. Like all the sheriffs around here, all the local police around here said,
Yeah.
we're not gonna support this ban.
The further you get away from Lake Michigan, the more support you have.
All right.
Having an FFL, I can tell you that the majority of my interactions with ATF, with the majority of the agents, the guys that are on the street, are trying to do the right thing. Give an example. I had a trace come across. They called me up, said, "Is this?" Yes. Hey, this is ATF Virginia. We need to talk to you about a trace on a gun. And I'm like, "Ma'am, I am a single person shop. I am out of town. I'm in Las Vegas. I will not be home till Monday. What do you want me to do? And they sat there and they said, okay, we'll put I said, well, if you send me the information, I'm going to tell you, I will try to see if I can get somebody to find the records, but the shop's not open for the whole week. We're closed. I'm out here. I'm the guy that does most of this stuff. Okay. And so they sent me the information. I was able to get my wife to find the paperwork. She did a great job of filing. And, we got the information back to them in a reasonable amount of time. And it turned out to be a friend of mine who I'd sold the gun to through the store who was burglarized and had the burglar in his house on his Ring camera. So obviously somewhere, somehow the gun has been picked up. So with that, they were completely reasonable to work with. All right. So I think the problem is you get the political part of the administration saying X, Y, and Z, and then that falls down on a lot of, the other agents. Are there some bad apples within ATF, like any other law enforcement organization? My experience with the majority of them, when we've had to work out stuff, has not been, an adversarial deal.
So I think that sounds like the ATF is more affected by political pressure, whatever's at the top.
They are.
Well, and look at the top levels of the FBI, right? You see the same kind of things, right? They're all political appointees, right? By whoever becomes president at the time.
Well, look at police chiefs. How come the rank and file FOP are different than the police chiefs?
Yeah.
And sheriffs are their own animal because they're elected. They're accountable to the voters. They're not accountable to the county board chair.
That's what I love about sheriffs.
They are that. So I look at all that. I look at all that and say, but I see somebody's recognized me on your
Yeah,
comments
Warsaw
there.
Patriot.
Yeah. So freaking watcher listener. It's awesome.
Yeah. As far as your the gun, the semi-auto gunman, I hate the term assault weapon. I only use it when I absolutely have to.
Is there any way to force them to define assault weapon finally?
They did.
What's their definition now?
Well, you have two tests. Test number one is it's on the list. The government has deemed this an evil gun. The test number two is a features test. There's a features test for rifles, a features test for handguns, a features test for shotguns.
So what's the feature? Because what's crazy is so I can carry my Beretta, 9mm Beretta, and take a 15-round mag in my Beretta handgun, right? My CX4, it's the same goddamn gun caliber. I can take the magazine out of that, put it in that gun, but now I can't use the same magazine in that gun. All the same gun. It's a short rifle, but I can't put as many in that as I can the pistol.
I got one better for you. You take that Beretta, take the barrel, I'll put a threaded barrel in it, and now it's an assault pistol.
Now it's an assault pistol.
So Eric knows one of my carry guns is a Glock 19 that I built up that has a threaded barrel and a optic on it. Okay, that is one of my carry guns. Under this law, it's illegal for me to carry that gun out in public. And what they do is this is their new. You've heard the whole sensitive places test.
No.
Well, no, sensitive places. They've talked about it where schools and governmental buildings from the court, sensitive places.
Yeah.
Well, what these lawyers from the anti-gunners got together to do is they didn't call them sensitive places. They said you can't take any of these firearms to places that are private property but open to the public. So it doesn't sound like a lot in the beginning, except you think about restaurants, all right, gas stations, grocery stores, all the places you normally visit during the day. If it's open to the public, they can't even tell you it's okay. It's so bad there are gun stores out there that are nervous that if they let their guys carry a full-size Glock with a 17-round magazine in it, that they're breaking the law. All right. And my attitude is that's why you should keep a loaded AR behind the counter. And, that's the common go-to. It's like the bartender with your shotgun underneath there, right? But this is what they're doing. So all public property, you can carry in forest preserves in the state of Illinois.
Mhm.
All right. But now, if you have a gun like I do, you can't.
That's
And so this is
So why? Because you're a better shot. That's assault. Now it's assault weapon. Now you're more accurate because
no
it's
it's
assault
because it has a threaded barrel
Right.
on the pistol. They now deem that to be an assault weapon.
right. What's changed? Better accuracy.
no,
Right? Was the threaded barrel? Was the threaded barrel change versus not having a
It
threaded barrel?
doesn't.
To
change
the
it.
Now you
old-
could put a suppressor on.
No.
Yes,
Yeah,
that's what. Oh, they're
yeah, that's what-
terrified.
Because you possibly can put a suppressor on, even if you don't have a suppressor on.
Yes,
Now it's an assault weapon because you could possibly.
or a compensator or a flash hider,
Right.
and they are just absolutely terrified by all those prospects.
I could see if you said, all right, because suppressors are illegal right now, but if you said, yeah, you could, if you carry it with this or you carry it with that, but just because you have that, that's
But think about the fact that you're now sitting there, and in this whole argument, it's like suppressors are not legal in Illinois. You're saying that just because that now falls into this category for no good reason other than it's the only difference between now and 94 is the list of features has changed that they're trying to ban. And then we get into this whole argument. So what do you do when you have common things going across platforms? So let's just use this as an example. AR-15 stocks have become some of the most common stocks on non-AR-15 guns.
Mhm.
Okay. So under the state's illustrations that they put forward, they sat there and said that they show a 1022, which they claim is not banned. I disagree. I think the 1022 is illegal under the statute. Number one. No, so then they show a 1022 that they have tricked out, with an extended mag, and they put a flash hider on it, and they
Right.
got a collapsible stock and all that, right? Okay, they said this is illegal because now you've converted. All right, so what have we changed about the lethality of that gun being a 22? Nothing.
right.
Absolutely zero. The ballistics out of that 16-inch barrel are what the ballistics are. Change the ammo a little bit here, a little bit there. You pick up a little bit, you lose a little. Nothing has changed. Okay, but take a Mossberg 500. You can get an adapter to put a pistol grip, a buffer tube or receiver extension, and a Magpul stock on the back of that. Looks cool. Some guys like it. Makes the stock a little bit more adjustable for smaller people, whatever.
Right.
Mossberg 500 is not prohibited under this ban. But can you legally get that stock, that extension, that pistol grip for a Mossberg 500? But there are also parts that are common to an AR-15.
Mhm.
Mhm.
This is the trick bag they
That's
have
where
put
the parts-
themselves in.
yeah.
And why? Because if we get the right to repair, our right to repair leads into a whole bunch of other stuff. And that's why that whole thing under Zell and the text and the enumeration of what's covered under the text. To me, the text of the Second Amendment, if it can cover the main, for you to maintain proficiency, then it has to cover me maintaining my firearm to keep it in an operational condition. And if I get that, that leads us down other paths or opens other doors for us to go down and keep, like Eric said, we're putting them in a smaller and smaller box, and we're expanding our playing field.
Well,
Go into the corner.
we're over an hour.
All right, I think that's good. Thank you to Todd and Eric for joining us. Give them the website if they want to go help donate and help the fight.
So again, it's the Second Amendment Defense and Education Coalition, SADEC.org. Big donate button right on the front page. And while I'm talking about it, I'm going to pitch Aurora Sportsman's Club too.
Give them a word. Club.
Right, guys, we are the largest private shooting club in Illinois. We've got 300 acres. If it's legal in Illinois, you can shoot it there. We have guys. We actually have a cannon department.
Oh, the cannon's
Right.
awesome. Wait,
Right.
The bowling ball cannon is cool as hell.
Yeah.
And the 50 millimeter cannon, I think it was 50 millimeter at the zombie shoot. But the bowling ball cannon, we're sitting there, we're behind the berm, and we're just like, you hear the poof, like you feel it in your chest, and you hear the
whistle.
yeah. We're like, what is that? It's like, oh, it's
Yeah.
a bowling ball cannon.
And the guy who runs that department for us is the largest private collector of artillery in the country. And so even if you don't have one, you're just interested and you want to learn how to do it, we're the place to go, man. It's really awesome
Awesome
stuff.
ranges. The zombie shoot every year is the coolest thing
Yeah.
ever.
Trap, skeet, 5-stand, sporting clays, wobble trap. Our shotgun department has the most amazing events. If you just like to shoot and kind of hang out and bullshit with people, they have big chili dinners, big barbecue dinners.
It's like being a Goldwing rider.
Yeah, it is.
What's longer? Is it 600 yards?
Yes.
600 yards.
600
I don't know where else in Illinois they have a 600-yard range.
Yeah. And we're putting on more ranges. We're kind of coming up to the end of a build out that we've been working on now for 4 years. We've got heated range buildings with Wi-Fi internet. You can bring out your whole family. We run programs for kids in the summer. So if you want to get your kids into shooting, we have really, certified people who have a lot of experience to do that. And the other program that Todd and I are really the most involved in is something we call TASK, training at ASC. And it is essentially gunfighting school. That if you're a member of the club,
in an urban environment.
You get 8 hours of training by guys who take classes from all the top trainers in the country for $20. Right?
Jesus.
If you're a club member.
Right, if you're a club member.
Right. And we're full, right? We actually we doubled the size of it this year, the amount of people we can take, and I still have people on a waiting list. Right. But if you're interested in doing that stuff and putting the guns that you've got and learning how to use them in that kind of environment, you need to come out to Aurora Sportsman's Club.
Yes. So 2 things. One, once you get to be a member and you get like your holster draw cert, which shows you can be safe, you can come out, set up steel, run your own drills. You can move and shoot. You can draw from a holster. All the things you can't do at most indoor ranges, we allow people to do on their own as club members. So you can shoot and move. You want to set up a lateral drill, you want to work on carbine skill, whatever. We allow people to do that. The other thing is we have some very talented big name guys in our guest instructor program. So John Maffei, the sheriff of Baghdad, he's coming out for his heavy carbine class and a pistol class in April. Yep, I'm going to be at the heavy carbine class. We have Tim Kennedy and Sheepdog. Mm-hmm. They were out last fall. They're coming back again.
They're doing all their Midwest classes with us now.
Yeah, we've got those guys. We've had Tactical Hive has been a staple of ours for a number of years. We're
getting Travis Haley back.
Yep.
We're getting Warrior Poet back this year.
We've had Graybeard out. Matt Little's been out a number of times. Eric and I have done his vehicle class. So if you want to come and do a bunch, we're trying to work with a couple of guys to see if we can't get Tonto out and do some stuff. I think those guys are hopefully.
If you're a USPSA IDPA guy, we had Tim Heron out, I think, for the last 3 years.
Yeah, we're doing all that kind of stuff.
Give the website for it. Just
AuroraSC.org. AURORASC, AuroraSportsmanClub.org.
Cool. Out there and check it out. Todd, you have a YouTube channel yourself, right?
So my YouTube channel is called Freedom Steel. We do have a promo video up there if you're wondering about the name. So we started this build out at ASC. We're adding 20 new ranges. That's what we're in the middle of. We're adding 20 new ranges. And I went, and what happened was they wanted a parking lot 5-6 years ago, and they just bought a Bobcat. I said, you're going to have me beat my head with a brick. And I said, let me go rent a bulldozer because I'm an operator. And we rented a D4, and they came back and they said, you put in 2 new parking lots and a 1,800-foot road in a week. Yeah, you give me the right tools, it's like anything. And so I convinced the board then to give me a budget to buy some used equipment. And we spent the money on an excavator, a track loader, and an angle dozer. Nice. And then a couple of years ago, when we started the mass dirt work, we bought a D8 T.
Moving some earth, man.
That was a $200,000 machine.
Damn.
And so the funny thing was, we're at a board meeting, and the insurance guy came out and said, hey, the underwriter wants to know why, out of all the gun clubs they insure in the country, and they insure hundreds, you're the only guys that have machinery like this. So we gave him a tour of all the berms that we are stacking up and all that other stuff. And he goes, okay, I get it. I'll take a couple pictures. And so hence the name Freedom Steel, because we got all the iron that we're using to build new ranges to protect our freedoms. And, that's what ARs and all that stuff are for. So that's the name of the channel. And there are videos up there about us building out the club. That's where it started from. And because of my long time being an NRA contract lobbyist, everybody was asking for 2A content in my comments on a bunch of stuff. So Eric got me to start doing some of that stuff. I try to get content up all the time, but right now working on these lawsuits, physically working on the briefings and the papers with the lawyers is chewing up. And once you see the stuff we file this week, you'll understand. And then we'll be able to talk about a lot more, like some of the things. But it's Freedom Steel on YouTube. You'll see some guys have started calling me the Gun Santa from some things and everything. So, but yeah, I'll be keeping up on Illinois gun politics and some of that other stuff. So
stay tuned to Todd's channel, see some of the updates, what's going on with the case.
Okay.
Jump in, help us out. Cold Dead Hands. We'll give some more money to these guys if you guys pick up some more. Go directly to the page. Go help donate there. Whatever you want to do to help hold on to your rights.
Yeah.
Thank you guys for being here today.
And
Awesome.
hopefully we
appreciate
can
you
have
having us,
as,
giving us
as a guest
opportunity.
again.
Absolutely.
sure.
You know?
Thank you
Happy to
guys
come
for
back.
joining us out there and watching.
Now
As
that we
always,
know where
thank
you
for your
are.
guys' support. Oh, don't forget, guys, while we're talking about it, the bourbon infused. You guys been asking. It's out. Go on the website. You can get it now. We're doing the pre-sale. You come in the shop and get it. Get it quick. It's going fast already. I tell everybody, don't be mad in 2 weeks when there's none left. Thank you guys all for joining us again. We'll see you next week.
Bye.
Bye, guys.
Drag out.
Yep, you're